and of course Huw Edwards, and well, 8 out of 10 people who commit similar crimes to him don't go behind bars. Is that acceptable to you? I wonder how much more tax would you be willing to pay to make sure there was enough space in prison so that people like Huw Edwards did spend some time behind bars? Because I'm really very happy to pay more tax for that. Let's talk about that right now with a criminal defence lawyer, Kotrie. He's also director of Mary Monson Solicitors. Liam, thank you so much for joining us.
Good morning, pleasure.
Thank you so much. Now, we're told, 8 out of 10 people who get convicted of similar crimes to Huw Edwards don't spend any time behind bars. They get a community sentence or a suspended prison sentence. Why is that?
I think the rates are probably higher for first-time offenders, if not closer to 100%, Julia. I think the reason for that is that they would be given a short sentence otherwise, a relatively short sentence. And Ministry of Justice statistics say that community orders and suspended sentence orders are much more effective at rehabilitation than short prison sentences are. So I believe that's probably more the reason than shortage of prison places.
So basically it's say, well, don't want to put these people behind bars, we want to rehabilitate them, we want to turn them around. Is there any evidence, because I'm pretty sure that there isn't any evidence, that actually people who have an interest, a sexual interest in children, can be rehabilitated?
I find it very rare that clients of mine come back to me with similar offences having been convicted the first time. Usually that knock from the police on their front door, often 2 years before, I think 3 years before Huw Edwards found himself in court, is enough to stop the activity that they are following.
Well, it scares the living daylights out of them and they don't get caught again.
Exactly.
But we don't know whether they're still looking. They may still have an interest in looking at indecent, abusive images of children, but they may not get caught, or they may not risk looking at them.
Yeah, well, of course, they wouldn't want to risk it. Often it's a relief. They're caught in this spiral. It's a compulsion. They're collecting these images. Sometimes it's hundreds, thousands, even hundreds of thousands of images that people download. They don't look at all of these images. It becomes a compulsion. And often it's a relief when the police knock on their door, that they can stop what they're doing, get the help that they need. Of course, they shouldn't be doing it in the first place.
And they can always go and get the help. I mean, there is that argument, isn't there, from those who say, these people don't go and seek help because they can't, because you can't admit that this is what you're doing. And I can understand that. You can understand why the average person, particularly parents, are going to say, I'm not going to say, lock the door and throw away the key on these offences. And certainly, we're looking at, category A images, some of them, but it's not like Huw Edwards was making the images himself, was abusing the children himself. It's not like he was going out seeking them. He was being sent them from this man. We understand those are the only images that he had on his phone that were of this nature, although another phone has gone missing. So we've got some question marks there. But, clearly this was not the worst offence of its kind. However, when we've seen with the rioters post the Southport attacks, judges choosing to jail people, sometimes for considerable lengths of time, for things that they've just done online. They haven't actually turned up at a riot, they haven't thrown a brick at anyone, set fire to anything, or threatened anyone in person. But when people have said things online, some of which were not incitement to violence. They were nasty, unpleasant, often racist things. You and I would not want to spend any time with these people, or would condemn these people. Right. But when the judges decide to jail those people because they want to send a message to other people, is there not an argument that we have got two-tier justice when they choose not to send a message to people with a very high-profile figure like Huw Edwards, who was probably only able to gain access to this young man who did send him these images, and indeed the 17-year-old who he paid 35 grand to fill his drug habit in return for explicit photos? Not, I think most of us bizarrely think, not a crime. Because of his position of trust, he abused the fact that he was a BBC News presenter who was trusted, and people would get in contact with him that way. Because of that role. Why do judges not think that that is an appropriate occasion to send a message?
Well, with respect, rather than a two-tier system, we might be comparing apples and oranges there, but I do understand the comparison that the public...
Well, they're both things that are on the internet.
Yes.
And you could argue in both cases, no one was specifically hurt by that actual act of him having the phone. A child wasn't wasn't re-abused because he had that image on his phone. The victimisation of the child...
they are.
I agree. The victimisation of the child happens every time someone views it. But I'm just saying, an extra child... You know what I mean. You know.
I know what you mean. I will answer the question. This was a spate of incidents, these riots, which were happening through different cities, and the judicial system, the criminal justice system, felt that it had to be nipped in the bud. These things were fast-tracked to the Crown Court, 7 days rather than 28 days, to show the public immediately before the next weekend came along, when people thought they might take part in similar activity, that this is what's going to happen.
But they're still doing it now, and the riots are long gone.
Still doing what, sorry?
They're still sending out sentences for threatening charges for people involved.
There has to be consistency, though. There has to be consistency.
No, but that's my whole point. There doesn't. We've just established there isn't consistency when judges, when the government says we want everything fast-tracked, when the judges decide, clearly with some instruction, they need to send out a message to stop the rioting, that they will take action quicker and they will give tougher sentences. We've already established we don't have consistency for the exact same crime with the same mitigating or extenuating circumstances. You will get a higher or a lower sentence depending on, was it at the heat of the moment in Southport, or is it something that happened a week earlier or a week later? So we are seeing inconsistency.
Well, it's still an ongoing issue that the race
but you don't need to hand out tough sentences now to deter people from rioting this weekend. There's no expectation there'll be a riot this weekend.
But it's still part of that. We're in the dregs of that space, of that situation. And just because someone's been identified at a later date doesn't mean they should be sentenced lesser than someone who's identified earlier.
But why should somebody be sentenced higher because they were identified earlier when they've committed the same crime on a different Saturday night outside a kebab shop at 2 a.m? They wouldn't get that sentence.
Because it had to be stopped immediately. That's why. And now those rights...
Well, you could argue those riots would have stopped anyway, but here's my thing. What about the message that we need to send out? I don't know. I was wondering if we've lost Liam's line. Is Liam still there? You're still there. Good. Sorry, I thought I'd lost your line. But again, if we're talking about, there's rehabilitation, there's issues of punishment, issue of deterrence, there's sending out a message. Why is it that judges and magistrates are happy to do that with one set of people, but they're not with, say, someone as high profile as Huw Edwards? We're sending out a message that looking at these images is going to land you in jail. That would be a very good message to send out to people, to men largely right now, who are looking at those images.
Well, the interesting situation about this case, the interesting part of this case, is that I've heard this mitigation many, many times. I've heard these allegations many, many times.
And this is my dad was horrid. I'm having a mental health thing. I'm wrestling with my sexuality. Poor me, I'm confused.
Well, I don't diminish the mitigation, but
I do.
They are scenarios. It's like, well, that's fine. You may free speech and all that. I know you believe in it, but it is important context. But the interesting thing about this particular case, the difference is that this case stayed in the magistrates' court for sentencing. Every case I've ever dealt with, and we're talking hundreds, has ended up in the Crown Court for sentencing. Category A images. This is the only time I've ever heard of it staying in the magistrates' court. Not only that, but Mr. Edwards wasn't made subject to a sexual harm prevention order, which is almost always the case when someone has been found with Category A images. The only time I've ever had it not imposed is when I had a client with just a handful of Category C. Of course, still serious, but relatively speaking, a lesser offence.
Yeah.
So I'm amazed that this case stayed in the magistrates' court. And the only difference that I can see in this whole situation is his celebrity.
So actually, he was treated more leniently. What would a sexual harm prevention order actually entail? Because he is on the sex offenders register, isn't he?
So, well, first of all, I wouldn't say necessarily leniently in terms of sentence. It still would have probably been a suspended sentence in the Crown Court, but perhaps a slightly longer one. Yeah. But the lack of sexual harm prevention order, yes. That imposes restrictions on your use of internet-enabled devices mostly, and not being able to delete your history, police software installed on each device so they can monitor your internet use at any time, producing your devices to police whenever asked. So people still have freedom to use the internet, but it is monitored. And it gives the public an extra bit of protection. Yeah. The judge in this case said that he was of no risk at all, or certainly of something along those lines. Yeah. And I'm surprised by that. The fact that he's been convicted at all of these offences suggests that he poses some sort of risk.
Yeah.
So
Well,
I would have
course.
thought sexual harm prevention ought to be.
But also, one of the things we know about paedophiles is they're really clever at hiding the fact that they're paedophiles. That's kind of the modus operandi. They hide in plain sight, working as priests, working in children's care homes, working on the BBC, like Jimmy Savile does, where you can gain access to children and in a position of trust. This man, we now know, was living a public lie for years. We already know he's able to deceive people. So when he says, oh, I'm not a risk, and his lawyer says, well, he would say that, wouldn't he?
Well, I'd certainly say that sexual harm prevention order and rehabilitation is something that's going to protect the public better than the prison sentence would.
Okay.
An interesting point I would make is that it's very rare, and quite surprisingly, that someone who has been convicted or has committed physical incidents of sexual abuse against children is also someone who has been in possession of indecent images. The two, in fact, rarely go together, which is, one might find strange, but it is, in fact, the case.
Okay.
Again, I've dealt with many of these cases over many years.
Really interesting to talk to you. I so appreciate your time and your expertise, Liam Kotrie, a criminal defence lawyer.